Please, Your Lordship. My Lord, this PIL has been filed on behalf of Yobin people, Yobin tribe. They are also otherwise known as Lisus, and they are residing within the Namdapa National Park. They are forest dwellers, but they have not been given that status, even though they have been there prior to 1960s. I have annexed some documents from the Northeast Trilogy and also from the Tirap Gazetteer, wherein it has been mentioned they were the first persons to be discovered in 1961 when the Assam Rifles came that site during the opening of the Vijayanagar post, administrative post also. Now, as per the Forest Dwellers Act, they are supposed to be given rights over the land since they have been residing much prior to 2006 when the Forest Dwellers Act came into being. Now the problem is that there is a notification for land acquisition in which their villages have not been included, saying that these are not government recognized villages. But the fact remains that they have been residing there much earlier. So as per the Right to Fair Compensation and Transparency in Land Acquisition Act, as per Section 3, Section 3R2, and landowner also includes any person who is granted forest rights under the Scheduled Tribes and Others Traditional Forest Dwellers Act of 2006. Now, since they have not been given this status, their lands will be forcibly taken away, and no compensation will be paid. Among all the villages that they've been residing, only 3 villages have been identified to be paid compensation. So my prayer is that till this Lordship.
Okay.
Yes,
Why PIL?
Lordship.
Basically, you are asking for compensation, claiming compensation.
Not only that, Lordship. Not only that.
And
We are also
status
seeking
status of
status of a forest dwellers.
Forest dweller.
Yes, because if only we are given the status of a forest dweller,
Why PIL?
Lordship, these are
You can come individually.
there are Lordship thousands of
Who are you?
Lordship.
Who are you?
I am Lordship. I am a
Guardian.
what? No, Lordship. I am also one of the members of the Yobin tribe, and
Okay.
I'm educated and I am able to place their grievances before this honorable court.
I think
There,
appropriate would be by individual application.
Lordship, it is not only a case of individual lands, Lordship. It is a thing which is affecting the whole of the Yobin tribe.
And at the same time,
Yes.
you yourself is saying that you are staying in the forest area.
Yes.
Namdapa forest.
Yes.
It's a reserve forest.
Yes, Lordship, I have annexed RTI documents to show that before this Namdapa Reserve Forest was declared, we were staying there. Now, Namdapa Reserve Forest was declared without any public notification. It was declared in 1983. We're staying much prior to that, Lordship.
Police notice
Lordship.
and keeping the maintainability open.
Lordship, and also Lordship, now they've issued this notification in which they've identified some villages. Out of our villages, only 3 villages have been included. Now they have sought objections from.
Have you filed the objection?
Yes, we have filed objections, but since our villages are not included, they won't take our objections.
In that
Yes,
list
yes.
of the
No, our names are not there. Obviously, our villages are not there. So obviously, we are not allowed to file objections even. Now, if they proceed with that thing, then it may create a problem.
Any application before all these claims did you make?
Yes, yes.
Where it?
Lordship, that would be page 145.
It is for compensation.
Lordship,
It is for compensation.
compensation, yes, Lordship. For prayer for forest rights have also been in 186. This was, we have done long time back. We have given many representations. That is why this is very voluminous.
Yes.
But in fact, first of all, my lord has rightly pointed out, this is basically for land compensation. Now, first of all, they will have to establish that they are having rights over that as per the scheduled tribe
No,
forest dwellers.
even if you don't have, if you are staying in the forest.
Yes, my lord. First,
under-
they have to
under the
establish.
act, under the act, they are entitled to have the
First of
benefits
all,
under the act.
no, first of all, they will have to establish their rights of scheduled tribes, other forest dwellers act, my lord. They have to establish their right, whether they are entitled under this act to have a right under the forest.
That is what they are saying.
Yes, they have to establish that.
They have established.
No,
They
my
are
lord.
staying over the, in
No,
the
my lord.
area, forest area, and under the act, if you
No,
are
no,
scheduled
my lord.
tribe, under the act.
That rights
Who are entitled under the act?
entitled, my lord, there has to be a recognized people who are recognized that they are there.
Are you saying they are not recognized people?
No, my lord. Now, that's why. And then the stretch of road, whether it covers, it passes through their land, that also has to be described. Because the road, what my instructions are, that road does not pass through their land also. The road, which is the old PWD road, it is widening of that road, and the acquisition is therefore there. It does not even touch their lawn. Now there are different within the number of
You file response, we'll.
yes,
need to
we'll
note
file response.
And we'll keep it, the
The maintainability also,
should be kept open.
because the chainage also has to be
Because
mentioned.
ultimately- It's individual right,
Lordship,
whether under the act of 2006
yes,
or the 2013 act.
Lordship. In order to Lordship, just by way of reply, as per the Forest Rights Act,
So we're not passing anything today, so we'll issue
Lordship,
notice.
because if our names are not, if our villages are not included therein,
No,
they,
they are saying that this road, which proposed road.
Lordship, that is the
doesn't
wrong
pass it-
submission. Lordship
doesn't
may
pass it
see,
through your-
Lordship may see page 269. This is the list of the villages, page 269.
269.
Yes. 269. This is the list of villages falling under Frontier Highway, Karsang Miao, Vijayanagar. This
Yes.
is the road, the concerned road. And Lordship may see serial number 17 onwards. 17 in between Gandhigram, that is in between serial number 18 to 21. Nibodi, Yachale, Sichoto. These are our villages. Our villages are within Gandhigram and Nibodi. Then this, it goes, then from Gandhigram, it's Ramnagar, this other places. We are saying our villages are within this, in between these places.
This Nibodi.
Nibodi,
Yachale-
Yachal, these are also our villages.
Is your
Yes, we are villages. There are other villages also, but other villages have not been included. Our villages are, yeah, 40 to 80 miles, Lordship.
How many villages, according to you?
10 villages. Out of 10,
Out of 10, 5 they have
three
three.
have been included. Gandhigram is also our village, but it is falling outside the Namdapa Park. So it is not a question. So they cannot say that it is on a different stretch of road.
Hard MS N. Duncan, Learned Counsel for the petition. By filing this petition, style is public interest litigation, the petitioner claims to be the seven villages. Now you are agree, people are from 7 villages.
Yes, but so far as Forest Dwellers Act is concerned, all the villages, 10 villages.
Uh,
The list has been mentioned in paragraph 2.
agreed by the non-inclusion of their villages, which is stated to be within the Namdapa Reserve Forest.
Yes.
Namdapa
National
Reserve
Park,
Forest,
NNP,
Namdapa National
Namdapa National Park.
National Park. Has filed this. Stated to be within the Namdapa National Park. Praise for conferring the benefits under the scheduled tribe and other traditional forest dwellers within bracket recognition of forest rights, bracket close, Act 2006.
And the rules, Lordship.
And the rules framed thereunder. And for compensation of their land under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013. For construction of acquired for construction of what is that land?
Karsang Miao Vijayanagar Frontier Highway.
For construction of Karsang Mayo Vijayanagar Frontier Highway within bracket 0.000 kilometer to 156.09 kilometer. That's all. Issue notice returnable by 4 weeks. Since Mr. N. Ratan, Learned Additional Advocate General, enters appearance on behalf of
2, 4, 5, and 6.
2, 4, 5, and 6, and Mr. M. Kato, Learned DSJ, for respondent number 1. No formal notice needed.
Lordship.
Extra copies be furnished to the Learned Counsel for the respondents.
Lordship, if the public notice is not stayed, if the acquisition process is over,
It's a construction of road, we cannot. And
That's
that
it.
your final with this is, what is that impugned letter?
which letter, Lordship?
That for hearing of for filing of the objections.
Lordship, there is page 272.
272.
Yes,
This was issued on 6th June. It
yes,
was supposed to be within 15 days.
yes. But this says it is, our names are not included, so there is no question of us filing any claims and objections on this. Our villages are not included.
So if it is not included, we cannot state this also.
I'm told that Namdapa Forest NNP have claimed the compensation instead of us. Namdapa National Park, the Forest Department has claimed the compensation instead of us.
In that case, you will have to approach the collector.
Lordship?
You will have to approach the collector only in that case. Land
That's it.
acquisition collector.
Lordship. But the
Next, considering the the claims essentially is for recognition and the benefits under that act, 2006 Act, and the compensation under that same act, right to fair, 2013 Act, where of the prima facie view that the claims basically, essentially, are individual claims. Therefore, the maintainability of the petition, this present PI, shall be considered on the next date.
Obliged.
Maintainability or otherwise of the present PI will be.
Right.
Yes,
My lord, I have been appointed the amicus in this case.
Yes.
I have not received a copy of the LCR over there, the paper book.
paper book. You have not received.
I have not received.
Is it a jail appeal?
Jail.
Jail appeal.
Yes, this is a jail appeal.
The learned amicus curiae, Mr. Tiki Pangin, submits that he has not yet received the paper book. I have also heard MSP Gini, the learned additional public prosecutor for the state board action Pradesh. The registry is directed to provide one copy of the paper book to Mr. Pangin. List after 3 weeks
Lordship can fix this matter for hearing, your lordship.
for hearing,
Yes.
for hearing.
The-
Lordship, an appeal against a conviction made by the special Oxford court Mongila in connection to Mongila Poxo case number 10 of 2000. What would the Lordship directly this honorable court can understand? What would the Lordship the question?
Today it is for order, the later
Yes.
for hearing,
So Lordship, one IA is pending
for bail.
that is bail application.
This appeal will be heard. Instead of this bail application, we will hear the appeal.
You are for 2 and 3.
2 and 3. Heard, Mr. P. Topu, the learned counsel for appeal. Heard MST Jimmy, the learned additional public prosecutor for the state of Arunachal Pradesh. Heard Mr. G. You are V. Mandal. No? APN for respondents 2 and 3. Paper book is ready. Yeah? You're for a victim. The 2 and 3.
2 and 3, your lordship, because 2 is the complainant.
2 is complainant, 3 is victim.
3 is victim. So you can appear for both of them.
Yes.
API for respondents 2 and 3. Paper book is ready. List after 3 weeks for hearing. In the I write lawyer's name saying
That's application number 70, that is what's regarding the bail of the accused person. So since already accused person was it convicted or so now almost this bail application is also pending from October 2022.
okay.
So date of conviction was on 10th of July 2000.
It will be considered at the time of hearing. of
23.
Yes.
9 2022.
Yeah. Heard so and so lawyer's name saying this application shall be considered at the time of hearing of the connected appeal.
Wait. Here also, my lord, I have been appointed as amicus on behalf of the victim, my lord.
Yes.
Here also records I have not received.
Paper book not received.
Not received. No, I say, नहीं ये से लेगा registration.
Heard Mr. T. Tapak. Yes. Appearing for the appellant. Heard Mr. Dicky Panging, the learned amicus curiae appearing for the victim.
Yes.
Heard MS H. Lakshmi. If the learned additional public prosecutor for the state of Arunachal Pradesh. It appears that the LCR has not been called for yet. Therefore, registry is directed to call for the LCR. On receipt of the LCR, the paper book shall be prepared. And after preparation of the paper book, this appeal shall be
तुमको मिला कि बोला है
listed for hearing. Copy of the paper book shall be given to Mr. Panging also.
man. All right.
Your lordships, I deeply apologize, your lordship. Mr. Tado, he had come this morning, your lordship. However, he had to leave the premise because of his health issue, your lordship.
As usual,
He had
as
just,
usual,
he had just left the,
as usual.
Well, kindly accommodate me for fourth.
Fourth,
Then I would be out of this court for 20 days minimum.
Where are you going?
Somewhere.
Where?
I'll let you know in the chapter.
It's so secret or what?
On fourth, Milord, I'll finish up. Because this poor fellow has been convicted for no grounds, Milord.
Yes. On fourth,
On fourth, Milord.
on the request of the learned counsel, Mr. Tikita, the hearing is adjourned to I have also heard MSTGD, the learned representative for the prosecutor for the state of Arunachal Pradesh. List for hearing, paper book ready,
Everything is ready. There's a final argument.
list for hearing on fourth
Correct.
of this month.
Oh.
Lordship, I beg to mention item number 26.
Item number
26.
26.
Yes, your lordship. Supplementary hearing. 26,
RSA,
RSA, your lordship.
yes.
My lord, I'm appearing on behalf of the petitioner.
Hmm?
I'm appearing on behalf of the petitioner, your lordship. May I pray that the matter may be listed after 2 weeks?
2 weeks.
Yes.
Who is for the respondent?
Mr. K. Lauren is appearing. We have already informed him.
Have you informed him?
Yes, your lordship.
The learned counsel MS,
The Tamuk, your lordship.
the
Tamuk.
appearing for the appellant prays for an adjournment and also submits that she has already informed the other side. The hearing is adjourned accordingly, list after 2 weeks.
My lord, I also beg to mention item number 28.
28,
Yes, your lordship. We are appearing for the respondent in this matter.
and MS so-and-so appearing for the. Have you informed the other side?
Yes, lordship. I'm for the petitioner, your lordship.
Oh, sir. The same order. After 2 weeks, same order.
may I, your lordship?
Yes.
Lordship, I beg to mention item number 27, your lordship. This matter may be listed on this 12th of September.
12th of September.
Yeah, I've taken consent for the petitioner, your lordship.
Okay. The learned counsel MS so-and-so. You are for the appellant, respondent.
Yes, your lordship. I'm for the respondent.
Appearing for the respondent. You are government advocate.
Yes, your lordship.
The government advocate, appearing for the respondent, prays for an adjournment. You are for the appellant.
No,
She has submitted that she has already informed the other side. The hearing is adjourned accordingly. List on when?
12th of September. your
12th of
lordship.
September.
And your lordship, also item number 15, your lordship. Here, your lordship, we have not received the
Paravise comments, so we need some more time for filing our counter affidavit. At least 4 week time may be given, Your Lordship.
The learned government advocate, MS so-and-so, a query for the respondent submits that she has not yet received the instructions from the state of Arunachal Pradesh, and therefore she prays for some time to file the reply.
Counter affidavit, Your Lordship.
On the basis of the prayer made by so-and-so, the case is adjourned today. After 4 weeks,
4 weeks, Your Lordship.
least after 4 weeks.
Oblige, Your Lordship.
May I,
Yes.
Your Lordship? Your Lordship, I beg to mention on unlisted item, Your Lordship. This is criminal petition on behalf of El Kurdu, Your Lordship. Your Lordship, this matter has been last posted on 29/7, and on the same order, it has been stated that matter may be listed after 2 weeks. However, till today, it's not been listed. So matter may
Do it
be
tomorrow.
tomorrow,
Tomorrow.
Your Lordship. Oblige, Your Lordship.
Your Lordship, I like to mention item number 4. Four. Lordship, the item number 4 is supposed to be listed for the hearing, and he today speaks for admission. And the senior counsel has fixed for the matter.
When?
My lord, a
on
specific date may be given, my lord.
specific date.
A specific date may be given. List it on the 12th. Next week, my lord.
But Lordship,
Item number 4.
on 12.
12 will be too early for him. Do you have the calendar? On 19th September.
Okay.
After hearing the learned counsels of both sides, the case is adjourned today. List on 19th September for hearing.
Lordship, interim order may be
The
continued.
interim order past earlier will continue until then.
Much obliged.
May I, my lord?
Yes.
My lord, I would like to mention item number 24, my lord.
24.
I'm for the petition. Yes, my lord, 24, 24. I'm for the petition, my lord. And I have taken consent from the respondent, my lord. Kindly matter may be fixed after 4 weeks, my lord.
Okay, the learned counsel, Mr.
T. Minky.
A query for the appellant prays for an adjournment and also submits that he has already informed the other side. On the basis of the prayer made by so-and-so, the hearing is adjourned today, least after 4 weeks for hearing.
Oblige me.
May I
Yes.
please, my lord, I beg to mention item number 3, my lord. My lord. If the matter may be taken
Item
up.
number 3 already adjourned. Huh? Oh, 4. What was adjourned? 4 was adjourned. Oh, you're for 3.
Yes, my lord.
Yes.
My lord, kindly if the matter may be fixed on 11th of September, my lord. 11th September, my lord.
11, it will not be possible. Arbitration appeal. 18, on 18.
Oblige.
After hearing the learned counsels of both sides, the hearing is adjourned today. Least on 18 September. Is it for hearing?
My lord, I'm not a counsel, my lord.
Okay, least on 18 September for admission hearing.
Oblige.
Ma'am,
Yes.
this civil revision application is directed against the impugned judgment passed by the learned district and station judge Pasigat in terms of the order dated 9/8/2023. Well, the fact everything is narrated in this matter is 1977, the Kaba was held in was the land dispute between the petitioner and the applicant and the respondent was settled. Then finally, what had happened was it went to the ADC. Then, because the ADC did not follow the procedural aspect of this case. So then what had happened, the petition, the applicant here came before this honorable court. This honorable court interferes with the directions of the district, the additional deputy commissioner. And then thereafter, in coming into force of the AP Civil Court, all those matters, my lord, under subsection 3, section 15 of the AP Civil Code Act. Then the matter was referred to the district and session judge, Pasikat to Basar. Then the district and session judge Pasikat was in charge, district and session judge Basar. Then, the learned trial judge, even could not able to distinguish who is the applicant, who should be the appellant and who should be the respondent.
Yes.
This is a very unfortunate. My lord, kindly come to this particular. My lord, I'll not detain my lord much. Kindly come to page 85 first. 85 to 90, that civil revision order passed.
Yes.
My lord, kindly come to para 2. The father of the petitioner, namely so-and-so of village Gauri 2 POPS Basar, district La Parada, purchased a plot of June land measuring 3.5 acres from one Sri Miken Basar of Gauri village on 26/12/1977 by executing a sale deed. Thereafter, in the year 1980, Sri Miken Basar claimed that the father of the petitioner has been occupying excess land sold to him, and thereafter a survey was conducted and found that the father of the petitioner has occupied excess of June land measuring 1.1 acre. Then, as per Galo customary law, the said dispute has been resolved by sacrificing a cow as community feast, and one male mithun and one brass ball was given to Sri Miken Basar in lieu of 1.1 acre of June land. Thereafter, in the year 1997, my lord will kindly mark 20 years later. Thereafter, in the year 1997, dispute arises over 1.1 acre of land, and then the matter was referred to village authority, local Kaba, and accordingly, the matter was resolved once again as per Galo customary law. However, again, on 15/5/1997, a second round of Kaba, purported to be a Bango level Kaba, was held, in which a decision was arrived at that Nyada Basar, the uncle of the petitioner, shall cultivate 2 bighas. My lord will mark this 2 bighas. The dispute is this. I'll show the map also. 2 bighas of the land which he has already cultivating, and Nyado Basar shall sacrifice any animal and give local brass plate to Sri Nyajom Basar, father of the petitioner, on the ground that both the parties in dispute are brothers in relation, and they should maintain cordial relationship in future. Thereafter, on 28/5/2014, Sri Nyado Basar filed a complaint before the additional deputy commissioner Basar against the petitioner for violation of purported Bango level Kaba order number so-and-so. In pursuant to the said complaint, the additional deputy commissioner Basar issued order number dated 02/06/2014, fixing Bango level Kaba to decide the land dispute between the parties on 16/6/2014. Thereafter, the Bango level Kaba was held on the day, and the decision was taken there that Nyado Basar shall continue to cultivate portion of the land, but will not sell the said land without the consent of the family members. Then, there being agreed by the decision of the Bango level Kaba, that is 16/6/2014, the petitioner, now Jumli Basar, along with his mother, filed a civil appeal number so-and-so before the learned additional district and session judge Basar, but the additional district and session judge Basar transferred the matter to the additional deputy commissioner Basar on the ground that regular civil court does not have the jurisdiction under Assam Frontier Administration of Justice Regulation 1945. Thereafter, on 11/3/2020, the additional Deputy Commissioner Basa disposed of case number so and so without affording any opportunity to the petitioner being heard and also without affording any opportunity of cross-examination to the witnesses. But the same error has been committed by the learned district and session judge in the impugn order. I'll demonstrate. My lord, kindly come to para 3, that Roman 3 is there in para 3 of this judgment.
Yes.
Roman 3, the petitioner, this is the ground, one of the major ground that we have pleaded in the previous this thing, in this, that the petitioner has not been afforded any opportunity of being heard and also not allowed to cross-examine the witness, and that the learned additional Deputy Commissioner Basa has failed to appreciate the law of position, the settled position of law, it should be, as the petitioner's father was in possession of the land for last 20 years, since 1977 to till 1997 without any intervention from any court, and therefore it is contended to allow the petition. Now, when law of adverse possession come, if we go to the schedule of Article 123 of Law of Limitations, then Lordship will find maximum is 12 years. So now that it is a settled position of law, and this was dragged into so far, then, my lord, what had happened? Finally, this honorable court, and last, Alia. Now, my lord, what had happened? All this, the impugn judgment rendered by then additional Deputy Commissioner Basar was interfered by this honorable court. My lord, kindly come to paragraph 14, my lord, page 93. And in view of judgment of a division bench of this court in Register General Guwahati High Court versus Union of India and others, 2013 for GLT 1109, and also in view of proviso to subsection 3 of section 15 of the Arunachal Pradesh Civil Code Act 2021, notified on 12/4/2021 in Arunachal Pradesh Gazette, the matter is remanded to the Court of Learned Additional District Judge Basa. The parties are directed to appear before the Court of Learned Additional District and Session Judge Basa within a period of 15 days from the date of receipt of certified copy of the judgment and order. On receipt of the order of this court, the Learned Additional District and Session Judge Basar shall proceed to hear the matter in accordance with law and make an endeavor to dispose of the same within a period of 3 months from today. Now, in terms of this particular order, the Learned District and Session Judge made a lot of efforts, including sending the matter to the Lok Adalat for amicable settlement, but then that could not materialize. And thereafter, my lord, kindly come to page 117. That is, this is the impugn order, which I am seeking for the indulgence of Lordship to grant me an stay order, because the order appears to be non-application of mine.
Okay, I will say this order.
Yes.
But the learned counsel, Mr. Tivita, appearing for the petitioner. Who is for the
Civil revision, my lord, notice has to go.
issue notice to the sole respondent. The petitioner shall take steps for service of notice upon the sole respondent by registered postal AD. List after 4 weeks. Till returnable date. The order dated 09/08/2023 stroke 2024 passed by the in charge additional district and sessions judge Basar, Western Zone, Leparada, in BSR stroke CA -12 stroke 2022 shall remain stay.
Until further order. Until further order.
Now, till returnable date, then put right list after 4 weeks. It is further directed that the order dated so and so passed by so and so shall remain stayed until further order.
Much obliged.
May I please your option, my lord?
Yes.
This is an application for quashing of a proceeding. My lord, case was registered under section 506, charge sheet was submitted. And my lord, from the FIR as well as the charge sheet, my lord, no any prima facie case is disclosed because
Charge sheet under section 506.
506. And Roshi is quite aware of the law written by Supreme Court that, my lord, unless and until the my lord, case doesn't satisfy the essential ingredients, mere act of, my lord, abusive act or abusive word will not constitute any offense. It is a matter relates to my land dispute. I purchased the land, then, my lord, inform and sold the land behind it. Then I, my lord, when I learn about the, my lord, fraudulent, my lord, disposal of the land, I approached to him from going from, my lord, Itanagar to Namsai. And there was some altercation, and only, my lord, the word I used as stated by PW2, that dekh lega, tumko dekh lega. This is the only abusive word, my lord. And on the basis of that, ultimately, a case was registered.
Okay, I will state,
My lord, I mean.
heard Mr. A.K. Forecast, appearing for the petitioner. Heard Mr. T. Ete, the learned additional public prosecutor for the state of Arunachal Pradesh. Issue notice. No formal notice is required to be sent to the respondent number 1 is because Mr. Ete has accepted notice. Extra copy of the petition shall be provided to him. The petitioner shall take steps for service of notice upon the respondent number 2 by registered post with AG. Least after 4 weeks. Till returnable date. The further proceeding of GR case number 162 of 2020 pending in the court of, where it is pending?
Pending Namsai, madam.
Which court?
Namsai.
Maybe
Namsai, my lord, JMFC.
pending in the court of JMFC, Namsai
Namsai.
shall remain stayed.
Oblas. Namsai to BMC. Oblas.
Oblige, Your Lordship.
My lord, item number 5 to 8 are connected matter, my lord. Item number 5 to 8 is connected matter, my lord.
Connected matter.
Yes, my lord, and my lord, kindly take up this item number 8 as
5 to 8.
Yes, my lord. And my lord, kindly take up this item number 8.
Item number 8.
My lord, this civil division petition is filed against the impending order. Impending order,
Execution.
no, my lord, impending mail order, my lord. Impending mail order. My lord, CRP number 11.
CRP number 11.
11.
Yes.
My lord, can you see page number 14, my lord? This is the, my lord, ex-parte mail order, my lord.
Ex-parte.
Yes, my lord.
Where is the order?
My lord, page number 14.
Did you receive the notice?
Yes, my lord, I have received the notice. My lord, however, I applied to produce case, a complaint, record of the case, but the head governor did not furnish me. So on that day, I was absent. And my lord,
Okay, all right. I will stay the proceeding time being. Who is appearing for the other side?
Lordship, I propose, Lordship, this matter may be disposed of, Lordship. Because already reply has been filed, Lordship. The matter is ready for hearing, Lordship.
Ready for hearing?
Ready for hearing. Instead of keeping it pending, Lordship, I propose if it can be.
in this case, only question is that,
So what is your reply?
Reply, Lordship, the proceeding was ex-parte proceeding, Lordship. If Lordship see the
Kindly come to page 6, Lordship.
Page number 6.
Page 6 of the petition, Lordship, revision petition.
Yes.
I'm reading, Lordship, the ground number 2, Lordship. 2, Lordship. That after receiving of the written complaint from the respondent, the Gambura of Model Blaze Nahalagan issued a summons to the petitioner on dated so and so, and the same was served to the petitioner on 13/7/2020 by directing the respondent petitioner to attend the mail hearing on so and so. Because summons was received by the petitioner also. After receipt of the summons and gone through its content, the petitioner surprised to see the allegation made by the respondent, as the same was not known to the petitioner. Accordingly, on dated so and so, petitioner filed application before the Gambura, requesting the Gambura to furnish a copy of sale deed enclosed in written complaint by the respondent, so as to file his written statement before the mail. However, the head Gambura failed to furnish a copy of sale deed to the petitioner. As such, the petitioner could not able to file his written statement before the mail and inform the Gambura that he will not appear the mail before furnish of sale deed annexed by the respondent. As such, no proceeding was held on so and so, and Gambura was supposed to inform the next that so and so and so. Here, Lordship, if Lordship see that this ground 4, Lordship. He applied before the next date because he was summoned to appear in a particular date, Lordship. Prior to that, Lordship, he approached the Gambura and he asked for the copy, Lordship. What he said, Lordship, if you don't give me the copy, then I will not appear in the next date, Lordship. The proceeding is that, Lordship. When date is fixed, Lordship, you have to appear before the adjudicating authority, Lordship. That's the court, Lordship. And you have to ask for the copy, Lordship. You have to inform the court that I have not been given copy, so therefore today I am not in position to file reply. But prior to that, he approached the Gambura and telling that if you don't furnish a copy, then I will not appear in the next date. Accordingly, on next date, he did not appear intentionally, Lordship. Lordship can read it from here, Lordship. So accordingly, ex-parte proceeding was drawn, Lordship. And that was supposed to be challenged before the higher appellate forum. Higher appellate forum is there, Lordship. This CRPC is civil revision petition, Lordship.
Appellate forum is there.
Appellate forum is there. Appeal has not been filed, Lordship.
So you should have filed an appeal. Where there is an appellate forum, High Court will not interfere.
Well, because in this order, the Gambura had access his power and jurisdiction. Kindly see page number 14. Page number 14, paragraph, second paragraph.
Yes.
Therefore, power conferred under section 44, clause 3 of Assam Frontier Administrative Justice Regulation Act 1945. I Sri such and such, head Gambura Model Blaze Nahalagan do hereby pass this order against Sri such and such to refund back the said amount of rupees 24 lakhs. Only along with the interest as per the bank or to give possession of the said land measuring area of 980. My lord, this order was passed under section 44 of clause 3 of the AFR. My lord. Under this provision, whether the Gambura can pass ex-parte order. My lord, kindly finish the section 42 clause 3. AP Court, volume 1.
Section 44.
Yes, madam, section 44.
Can you tell me the page number?
Page number 66, madam.
66.
Yes, madam.
Yes, 44.
Yes, madam, before coming to clause 3, madam, kindly see clause 1, madam. Hearing of the case in Blaze Authority, madam. Madam, all
Yeah.
clause 1, madam.
44.
Yes, 44 clause 1.
44? Clause 1, yes.
Yes. All the suit tried by the blessed authority shall be decided in offender in presence of the parties and at least 3 independent witnesses. My lord, under this section 44, my lord, proceeding has to be conducted in presence of both the parties, my lord. And my lord, kindly see clause 3.
Yes.
After hearing both the parties and their witnesses, if any, the blessed authority shall pronounce a decision, my lord. After hearing both the parties, my lord, there is no provision for ex parte under section 44 of AFR, my lord. Therefore, my lord, this order is violation of section 44 of the AFR Act and against the natural justice, my lord. And my lord, there is my kindly face number 25.
25 of the record.
25 of the petition, my lord. Revision petition, my lord.
Yes.
My lord, kindly section 11, my lord.
Yes.
My lord, when the blessed authority can initiate an ex parte, my lord. May, my lord, section 11 clause 2, my lord. The blessed authority or the inter-blessed regulatory council affects, as the case may be, may pronounce or take ex parte decision if one of the disputing party does not turn up or remain absent willfully for 3 consecutive times after giving not less than 30 days on each occasion of reasonable opportunity of being heard. Ex parte proceeding can be initiated under section 11 of the Amendment Act, my lord. And that has to be 3 consecutive, my lord, occasion, my lord, by giving 30 days time, my lord. Here in this case, my lord, only one occasion they passed the order, ex parte order. So, my lord, prima facie, this order is prima facie illegal, my lord.
Lordship, so far this amendment is concerned, Lordship. To some extent, this is correct, Lordship, because as per the amended provision, Lordship, 3 consecutive opportunities should have been given, Lordship. That's correct, Lordship. And if Lordship come to the CPC says if there's a proof that the someone has been delivered, then ex parte is at the discretion of the court, Lordship. Anyway, Lordship, may I propose, Lordship, this matter may be remanded back to the blade authority, that's the Gambura, Lordship.
To decide afresh.
To decide afresh, hearing all the parties, Lordship.
Yes, my lord.
And till then, Lordship, status quo we maintain, Lordship. That would be, I think, most.
What do you want to say?
Lordship, I for the item 5 and 6.
5 and 6, yes.
Yeah, Lordship, these all are connected. Because here, Lordship, the mail order has been passed in between this petitioner in item 8. But the respondent here, they have filed an execution application against that mail order, Lordship. And the executing court, while initiating the execution proceeding, they have implemented us. I am nowhere in the mail proceeding.
Okay.
Therefore, if the mail order is gone, then of course I have no case here.
Yeah.
Lordship, my prayer is, Lordship, because he is a third party, Lordship, who is interfering into the positions of the suit lane, Lordship. When suit lane itself is dispute between the Lordship, the first petitioner and me, Lordship, then no activities may be carried out in the suit lane, over the suit lane. They will, Lordship, they will have the further implication, Lordship, the further accrual of the Lordship new course of action, which cannot be permitted, Lordship, when they should. So the matter may be remanded back and status quo
has not been decided between the private respondent and me, Lordship, because I have also purchased the same land. And what the respondent are also claiming.
All right. Heard, Mr.
Forwarding.
Appearing for the, first of all, you write, this is a common order for these 2 items. Heard, Mr. So-and-so appearing for the petitioners. Heard, Mr. So-and-so appearing for the Respondents? The head Gaobura model village, Naharlagun, issued notice to the petitioners. In respect of a man, the petitioners received notice stop on one occasion, they appeared, but subsequently they did not appear. Therefore, ex-parte judgments were passed against the petitioners. Where the learned counsel for the petitioner has pointed out that the provision of section 44 of the AFR has no provision for passing an ex parte order. The learned counsel further pointed out that according to AFR, Administration of Justice Regulation within bracket Amendment Act 2023, it has been mandated that before passing an ex parte order, how many adjournments? Three consecutive adjournment should be granted. Where the learned counsel for the respondents also agreed to that provision of law. Where after hearing the learned counsels of both sides, this court is of the opinion that the petitioners deserve to be given an opportunity to contest the proceeding before the head Gabura. Therefore, the impugned ex parte orders dated 18/7/2023 on the same day.
No, on 18.
One is on 18 and another is on
Pass on 18. Case was fixed on 15.
huh? Give me the other record. This is LP11. Oh, it is here. It is here. It's 26. On the same day, 18/7/23. The impugned ex-parte orders dated 18/07/2023, passed by the head Gaubura, Model Village Naharlagun Circle, Arunachal Pradesh, are set aside. The case is remanded to the village Gaubura for deciding afresh after hearing both sides. With the aforesaid direction, both the religion petitions are disposed of.
What's it, interim till then?
It is further directed that
Parties sell.
It is hereby directed that the parties to the dispute before the village Gaubura shall maintain status quo in respect of the suit land.
Lordship. And no construction may be made.
It is clarified that no construction work shall be done or no third-party rights shall be created in respect of the said land without the permission of the village Gaubura.
Correct.
May I have since I have started my construction, so direction may be issued to the village authority so that we specific date or month.
Then time frame may be given to the village authority.
It is further directed that the village Gaubura shall decide the matter within next 6 months.
Not say
3 months.
3 months.
within 2 months will be more than that.
2 months will be too.
Because all the parties are here.
3 months would be.
Within next 3 months of receiving the copy of this order.
In that case, Lord Sir, I would be the apparel, Lord Sir, because I have already constructed over.
You wait for some time.
Activities is going on.
Within 3 months, it will be disposed of.
Okay.
The, in the both the IAs, right, in view of the order passed in the connected civil division petition, the present interlocutory petition has become infructuous and closed and disposed of.
Okay.
What is the offense?
May please, Lordship.
Yeah.
Lordship, this
Oh.
is the regular bail application. For the-
Trial is going on.
Lordship, trial is going on.
How many witnesses are examined?
Lordship, so far only victim has been examined so far.
Victim.
Lordship.
It's a successive bail, your lordship. Earlier, your lordship has rejected this bail application.
Lordship, on dated 11/3/2024, this honorable court has rejected the bail application of the alleged accused person with a direction that he has a liberty to file bail application after recording of the 5 number of prosecution witnesses. But Lordship, it is pertinent to mention that so far, Lordship, only one prosecution witness has been recorded so far, and she is the victim of the present case. And Lordship, of course, I am not going into the merit of the case. Lordship, here in this case, the victim has already deposed her statement on 20th day of 2024. There is annexure 5, page number 27 of my bail application. Lordship, here there is no any, the evidence deposed by the victim is not sufficient to make out a prima facie case against the accused person. And Lordship, the other remaining witnesses, they are official witnesses and the relative of the accused person who are not so relevant for the trial of this case. Lordship, since the accused person is languishing in the custody for more than 404 days, Lordship, I admit that the allegation in this case is.
Is this a POXO case?
Lordship.
Yes, your lordship.
But our age is shown as 21 years.
Yes, Lordship.
Now 21 years.
Yes.
At that time, probably she was a minor.
Yes, Lordship. Lordship may read the statement of the victim, page number 27, annexure 5. This is the statement, deposition on oath.
She has been.
My lord, victim have no objection if.
She done hostile already, your lordship.
Lordship, they have already filed quashing petition before this honorable court for quashing of this entire proceeding and FIR, which is pending before this honorable court. So considering those facts and circumstances. Where is the FIR? Lordship, this is already charge sheeted. FIR is at page number 13, Lordship. Annexure 2. Please read the FIR. Okay. To the officer in charge, Police Station Doimuk, FIR against Sri Kengari.
My lord, this is a bail application, my lord, for 39, my lord. The accused person, my lord, has been in the custody since last 7 months, 8 days, my lord. Now, my lord, charge sheet was filed on 27 to 2024, my lord.
Notice upon respondent number 2 served or not?
Lordship, yes, sir. Upon respondent 2 is not yet complete. That is, service has not been complete, Lordship, upon respondent number 2.
Oh, the respondent number 2 has to be heard.
Then, Lordship, LCR record also may call for.
LCR not called for.
No, Lordship.
This is bail application. Case already disposed of or is pending?
My lord, charge is yet to be filed. Charges are yet to be framed even, my lord.
Okay. Heard Mr. R. Sona, the learned counsel appearing for the petitioner. Heard Ms. H. Lakshmi, the learned additional public prosecutor for the state of Arunachal Pradesh. Issue notice to the respondent number 2 through the concerned police station. The petitioner shall take steps accordingly. Para. Also call for the scanned copy of the LCR. LCR along with the statements of the witnesses recorded under section 161 of the CRPC. List again on.
It will be on 16, my lord.
16 September.
Deeply.
Right, Lordship.
Yes.
My lord, we have received paper book, your lordship. We have received a copy of the paper book, your lordship. May I pray that the matter may be listed for hearing?
Okay. You have received a copy of the paper book?
Yes, your lordship.
MS pay for the review petitioner.
D. Tamuk, your lordship.
Or do you appeal?
Yes, your lordship.
Appearing for the appellant. Heard learned counsel so and so appearing for the appellant. Heard Ms. H. Lakshmi, the learned additional public prosecutor for the state of Arunachal Pradesh. Who is for the respondent number 2?
PP, your lord. None has appeared, your lordship. Late.
Notice served or not?
Yes, your lordship.
Notice. Wakalaknama filed by the learned counsel on behalf of the appellant. Steps. Causing service upon respondent number 2. Surface of notice upon the respondent number 2 is incomplete. As the learned counsel for the petitioner has not yet taken steps. The appellant is directed to take steps for service of notice upon the respondent number 2 to the concerned police station. The petitioner shall take steps accordingly. List after 4 weeks.
Much obliged.
Who is for the other side?
Lordship, DK Diori. DK Diori.
For the other side? Notice served or not? And 4 died. You have to implement his legal heirs. Heard, Mr.
S. Iram.
Appearing for the review petitioner. The petitioner is directed to take steps for service of notice upon the respondents 3, 5, and 6. Through by registered posted AD. Para. Respondent number 4 has expired. The learned counsel for a petitioner prays for some time to file appropriate application for implementing the legal heirs of the respondent number 4. The prayer is allowed, least after 4 weeks.
Item number 13.
Event 13.
Yes, Lordship.
Service report not yet received. Heard Mr. So-and-so appearing for the petitioner. Seen the office note dated 31/08/2024. Await for the service report in respect of the sole respondent. Least after 4 weeks.
Lordship, interim order is there.
The interim order, comma, if there be any, comma, shall continue till the next date of listing.
Any other list?
Item number 14.
Your Lordship, service report in respect of respondent number 2 and 3 is still wait.
2 and 3. You want to wait or take fresh steps? You want to wait?
Yeah, we have taken steps twice.
But notice has to be served. East Siang,
Yes, yeah.
Pasighat.
Pasighat.
Notice should have been served. Did you take steps by registered post? How? Nowadays, speed post is there. You can take by speed post also. It will be better if you send the notice by speed post. You can track it. You can get a tracking report. So it is very easy now. Heard, Mr.
J. Karbak.
Appearing for the petitioner. Heard, Mr.
E. Minky.
Appearing for the
Respondent number 1.
respondent number 1.
Yes.
Seen the office notes relating to service of notice upon the respondent number 2 and 3. The petitioner is directed to take fresh steps for service of notice upon the respondents 2 and 3 through speed post. So you will be able to track it. Served or not, you will know. At least after 4 weeks.
And you said there is an interim order. There is an interim order.
Interim order is there.
Yes.
The interim order shall continue till the next date of listing.
Obliged.
Yes.
Your Lordship, in this case, I have received the paper book, Your Lordship. Paper book, Your Lordship.
Paper book.
Yes, Your Lordship.
Ready?
Yes, received the paper book, Your Lordship. Matter may be fixed for hearing, Your Lordship.
Heard the learned counsel, Mr.
E. Menjo, Your Lordship.
Appearing for the appellant. The paper book is ready. So what was the sentence? How much was the sentence? Seven.
Your Lordship, 4 years.
4 years.
Yes.
How many days he's in custody?
No, Your Lordship.
He's on bail.
Yes.
Then least after 4 weeks for
Yes.
hearing.
Much obliged.
Yes.
Mayor, please, Your Lordship. Your Lordship, can you take up the item number 18 first?
18.
18. CRP 16
Okay.
of 2020.
16 years.
Well, here it is case where the petitioner, we took a loan of rupees 10 crores from the Apex Bank by mortgaging our land with the land of the guarantor. But we have failed to repay the loan. So the bank authority sent the matters to the Pakistan officer under the provision of Bengal
Public demand security. Yes.
the melody that while the case is pending there, the matter was sent to the Lok Adalat. In the Lok Adalat, the notice was issued to the petitioner. The petitioner appeared and the case was fixed at rupees 10 crores by waiving all interest and charges. And the matter was sent to the bank. The bank did initiate a proceeding, execution case, putting that award of the local adalat into execution. In the said execution, the notice was issued to us, and we have stated that we are unable to pay that entire amount. Therefore, the land mortgage before the bank that may be released on us so that we can sell the land and pay the bank money. Accordingly, the bank issued NOC, and we made all steps by publishing notice in the local newspaper, but we are unable to repay the loan and sell the land. Thereafter, we made a prayer before the bank that we are unable, therefore you take the appropriate steps for the sale of the land. And to that effect, my lord, we filed a petition. That petition was registered as IA 34 of 2000. It is at page 52.
52.
Oh, sorry. Petition is page 48.
Yes.
In an application regarding the inability to sell the mortgage property in connection, so. Next paragraph, my lord, the applicant's husband is a citizen of India. The applicant's husband respectfully submitted he has tried to sell the mortgage property and has been kept as a collateral security and obtain the loan in question. However, it is to submit that despite sincere effort by his husband letter, he is unable to sell and dispose of the mortgage property. The applicant's husband letter states that facing the extreme financial crisis, though he had undertaken to repay the loan by selling the mortgage property, he is unable to get the value of the same, since the property already mortgaged to the respondent bank as collateral security. The bank has liberty to realize its dues by selling the land, which the petitioner has no objection. But this petition was heard and disposed of by the improved order at page 52.
52.
52. The learned executing court discussed everything. And my lord, what happened is this. The learned executing court directed to issue a warrant to civil warrant to put the judgment debtor in prison. This is not the provision of law. Civil prison can be used only exhausting all the remedies. When I have very specifically stated that I am unable to sell my land, you are hereby authorized to sell the land and get the money. It is already mortgaged in favor of the bank. Even though the learned magistrate or the learned executing court passed the order, your lordship kindly see next page, that is page 53, is where hard. Since the instant execution case in connection with local award, which has passed on 9/3/2019, the instant execution case has been pending before this court since 3/2/20. Also, since this AD appeared in the court on so and so and so and so, has short time and accordingly time was given to the ZD to make payment. However, till ZD has not made any payment of the instant execution case, is delayed due to non-payment by the ZD and another reason. Accordingly, the prayer for the instant miss case is hereby rejected in order to enable the speedy disposal of the instant execution case. In view of the order, the submission the learned counsel to DH that view that the stated above facts of the instant case, issue civil warrant of arrest against the ZD. Where in my petition I have stated that I am unable to sell the land. It is the duty of the executant case to proceed to sell the land. There are various ways under Order 21. Why is instead of doing this, is put the ZD into civil prison. That is not a procedure. It is absolutely irrelevant, irregular. Therefore, the procedure for civil imprisonment is the last remedy. Suppose I am put in the position of civil imprisonment. The bank will not get nothing. It is only, it may be a pressure tactics. But I express my inability that though I tried, I am unable to sell the land. Therefore, I asked you to give you the property and you sell it, realize the money.
You asked the bank to sell it.
Yes, my lord. I have very specific.
This is for the bank.
No, my lord. Your lordship will, if your lordship peruse the order, lordship. What happened here in the petitioner voluntarily took all the documents from the bank. We even issued NOC saying that he will sell the land and give the money to us, Malad. Your lordship will, if your lordship peruse the order, Malad, that's what the learned court has said, Malad. There's nothing illegality, Malad. Lordship, just the same page Lordship has already seen. Can you say what the learned court has said, Malad?
Right. You are appearing for both the respondents.
Yes.
You are for both.
Yes. Your lordship, can you see page for 52, the order passed by learned court below. No, second, third. Learned counsel, JD has submitted that ready to pay rupees 10 lakhs is the corresponding instant case and paid the civil warrant by arrest may issued against JD. Further, learned counsel for the applicant has filed IA such and such, stating that JD is unable to sell mortgage property which is taken as collateral security by DH and is prayed that DH may be sell the land mortgage property. Learned counsel for the DH has objected to a prayer, made an instant application and has stated JD has already sought NSA from DH for sale of the said property and DH has issued NSA to JD to sell the property. DH is not ready to accept said part payment installment amount of rupees 10 lakhs when the amount liable is rupees 10 lakhs, 10 crores only, and has considered the fact that the installment amount fixed was rupees 1 crore 66 lakhs 7,000 only wide for 6 installment the Lok Adara Award of 9/3/2019. Well, he has already, that paragraph already reflects, but it is the petition's own, that one, that he would sell the property. In the additional affidavit which they have filed now also, Lordship will see additional affidavit. They have already advertised. Lordship will the rejoinder which they have filed. Lordship.
Okay, we will go for a hearing of this matter.
This is a civil revision, my lord. The amount is very huge, more than 16 crores, which the judgment debtor has to, but it's a public money, my lord, it depositors' money. It's not bank's money.
No, even though, my lord, I have very specifically stated in my petition that I tried to sell the land, I made a paper advertisement, but I am unable to sell the land. Therefore, I requested the bank to sell the land and get the money. Therefore, what happened is this, my lord. Whether the issuance of the order for put the judgment letter in civil petition, whether that is legal or illegal. That point your lordship is to look into.
Okay.
I feel that is different thing. Whether all provisions are exhausted, then only the putting the person.
This is the final step.
Yes,
Sending people
final
to-
yes.
It's 2019 decree, my lord. Almost 5 years, my lord.
We will go for hearing. Heard till under senior counsel, Mr. A.C. Sharma, assisted by Mr.
Yes, my lord, it may fix for hearing.
Assisted by Mr. So-and-so. Heard Mr. T. Tapo. The learned counsel appearing for the respondents. List this matter for hearing after 4 weeks.
No, my lord, it may be because it's the bank is, my lord, in the urgency, my lord.
You have waited so many years. Now, what is the urgency now?
Now, my lord, they have come before this honorable court. My lord, they even didn't deposit a single penny, my lord. Otherwise, they should have deposited some amount.
You wait for 4 weeks. Till returnable date, the impugned order dated 12/04/2024, passed by the learned civil judge senior division, Capital Complex, UPA, in money execution case number 04/2020, shall remain stay.
And the records may be called for.
Huh?
Records of the money execution case may be called for.
It is also directed that until further order, the entire money execution case number 04/2020 shall also remain stay.
Pending in the.
Oh, what was the other item?
Same matter.
Same.
Same, my lord, two
Different amount.
different amounts.
For two different amounts.
Yes. One is 10 crore, one is 6 crore.
Oh, that's it. Then money execution case number will be different.
Yes.
In the item number 15, item number 17, money execution case number will be different. Is money execution case number 05/2020. Remaining part is same.
Mm-hmm. 17 of petition.
Can it be listed on, my lord, 23rd September?
21st September.
23rd.
It is good for hearing. That
Yes,
is why I am directing to be listed after 4 weeks. It will be listed after 4 weeks. It is a hearing matter.
And records may be called for.
Records, my lord.
Records are not required.
necessary, my lord.
I have listed.
19 and 20. This is the civil division petition.
But in this both matter, my lord, I am for petitioner,
You are for the petitioner.
my lord. And in this both matter, my lord, there are IAs.
You are appearing for all the 4 petitioners. And Mr. Sonar is appearing for?
Respondent. my lord.
My lord, I am for the respondent, my lord.
You are for the all the respondents.
No, my lord, here, my lord, 4 respondents.
No, it is many respondents. Who are these persons? 19 persons are pro forma respondents. You are not paying for them,
My lord,
for pro forma respondents.
I am not for the pro forma respondent. my lord.
You are only
I am
for,
for the, my lord, this respondent number 1, 2, 4, my lord.
not 3,
1, 2, 4. 1, 2, 3, 4.
1, 2, 3, 4.
Yes, my lord.
For others, will they pay? Notice served or not?
We are the plaintiff in the main title suit.
We have taken step.
My lord, in this case, my lord, the two IAs have been filed, my lord, but I don't understand why IA have not been, my lord, listed together with this main FAO 3 and revision, my lord. The two IAs I have filed, my lord.
Not listed today.
There is urgency in the matter, my lord.
You listed, you not listed. Not listed,
My lord.
I is not listed today.
It should have been listed together. Already my friend has taken notice on the IA. He has taken this copy I have served. He is supposed
We'll be
to
filing
file
reply, my lord.
He is supposed to file the, my lord, reply. But even after, my lord, it's almost going to be 2 months. My friend is not filing. Its reason is very obvious, my lord, because he has obtained ex-parte interim order against the, my lord, order passed by the, my lord, learned civil judge. That too, my lord, order under 39. Now, my lord, I will demonstrate, my lord. Apparently, my lord, this first, my lord, I would my lord, pray with this honorable court, my lord, kindly take up
Today, this is for order, my lord.
Actually,
This is listed on orders. So we need some more time to file reply on IA, my lord.
In the IAs.
IA, my lord.
IAs are not yet listed today.
This is the difficulty, my lord. Let
That's why,
the
my
IA
lord,
comes up with
so
this.
far, my lord, IA both can be listed together, my lord.
Yes.
Then, my lord, very short date, my lord.
Next week?
Yes, my lord, because
Next
urgency is
week,
there,
my lord, I'll be not available, my lord. Till 11, I'll be not available.
Till 11, you will not be available.
My lord.
Then 12, 13?
Can it be on 25th September, my lord?
No, my lord will see. It is something, my lord, I am the duly elected executive body of a student body, my lord.
Okay.
Now, my lord, all of a sudden, my lord, this election has been declared null and void, my lord, without any authority, my lord. By order of one, my lord, person only, single person, arbitrarily, my lord. Now, my lord, being agreed by thereby, I file a title suit, challenging, my lord, declaration of the election result as null and void. The learned trial court below, my lord, has, after exhaustive hearing, my lord, giving all the chances to the defendant, my lord, has passed the order under 39, my lord, suspending the interim order. Now, against that, appeal has been filed in this honorable court. And this honorable court, my lord, without hearing me, that has been order passed. Now, my lord, only on one ground, that suspension has been done, my lord, saying, my lord, that there is no pecuniary, no territorial jurisdiction or pecuniary jurisdiction. And my lord knows that, my lord. So far the CPC is concerned, my lord, you cannot raise the issue of territorial or pecuniary jurisdiction for the first time before the appellate court, my lord. You have to raise this by way of filing the required application under Order 7 rule is there, my lord. That exists not done, my lord. They did not challenge nothing there at there, my lord. First time they filed the application.
It is their contention, my lord. Kindly peruse the petition, appeal, my lord.
I will show, my lord. Now, second, my lord. Another question. My lord, we'll see whether 5 lakhs, because this appeal, my lord, is the pecuniary value is 5 lakhs. Whether 5 lakhs appeal is live before the High Court, my lord. My lord, I will show, my lord, from the Arunachal Civil Court as well as Assam Agra Act, my lord. 20 lakhs exceeding value only, my lord, appeal will lie before this honorable court, my lord. My lord, he has to go to the district court, my lord. The value is of 5 lakhs, my lord. How the appeal will lie before this honorable court, my lord? This appeal itself is not maintainable, my lord. Now, my lord, I will show the appeal. My lord, kindly turn the item number 20, my lord.
CRP number?
My lord.
If, my lord, he is hurt, my lord, I may be also allowed to reply, my lord.
I am
So that your lordship may not be confused.
I am just showing
Today, this is not for hearing, my lord.
I'm showing the document.
If he is allowed to argue, my lord, I may be also allowed to argue, my lord.
Let the IAS be listed first. On the day.
My lord.
Mr. R. Sunar The learned counsel for the respondent has pointed out, who filed the IAS? You filed.
He filed.
I filed,
Has pointed out that he had filed two interlocutory applications
In CRP, my lord, 25 of 2024
in
It-
CRP number 25 of 2024
and FAO 03 of 2024.
and in FAO
03 of 2024.
03 of 2024. Those two interlocutory applications are not listed today. Therefore, the registry is directed to list these two items on 19 September along with the said interlocutory applications.
Highly
on
obliged.
16, my lord.
16 Monday,
My lord.
on 16 September.
And my lord,
Highly obliged.
they should not seek further time. My lord can understand, my lord.
Meantime, my lord, there are interim in both the CRP and FAO.
No,
That
my
may be
lord, my
continued.
lord, there is a issue, my lord. So far, CRP is concerned, my lord, interim can be extended, my lord. So far, FAO is concerned, my lord, last order, my lord, it has not been extended, my lord. Since in the last order, my lord, when it was listed on, my lord, 31/7/2024, my lord, when it was not extended because earlier interim was still returnable date, my lord. Therefore, my lord, it cannot be extended now.
Now, may I submit, my lord, on this aspect? Why that was not extended, my lord? In the meantime, they have filed this IA for vacating modification of that interim order. And that is the reason this honorable court did not extend it. Simply made an order that this will be listed along with the main case, notice issued. And that will be always subject to the outcome of that IA, my lord. Therefore, it was not extended.
My lord,
And otherwise also, my lord, in CRP, entire title suit number 19 of
so, my lord,
2023 is
CRP is concerned, my lord, I am
suspended, my lord.
no issue, my lord, because
All right. In CRP 11,
let it be extended CRP, my lord.
24, the interim order past LS will continue until next date of listing,
Till returnable date.
till returnable date. List along with item number
FAO
20, my lord.
20. List along with item number 20.
That's
And
wrong.
item number 20, my lord, interim has to be
No, my lord, I have
continued, my lord.
strongly objection on that point. Because otherwise, my lord has to see whether there's a primary, because last time not extended, my lord, I have,
On this technical issue, my lord,
It was an injunction order.
my lord, injunction order.
injunction order, it was granted that this honorable court prima facie in both civil revision and FAO, my lord, this honorable court prima facie found that there was a forum hunting, my lord.
Okay, all right.
There was a forum shopping, and that is the reason,
On 16, it will be heard.
my lord, till 16, this may be,
The interim shall not be extended in
My
FAO.
lord, deeply objection.
my lord.
Is it for,
May I please, Lordship?
for quashing?
Yes, Lordship. This is joint petition.
Joint petition.
Yes, joint criminal petition by the petitioner number 1 and 2. Petitioner number 1 is the complainant.
What are the sections? 448, 323, 380.
Yes, Lordship. Lordship here, 448, punishment for house trespass. 323, voluntary causing grievous hurt. 380, theft in dwelling house. 506, punishment for criminal intimidation. What happened, Lordship? The fact of the case, here both the petitioners are the ex-husband and wife, Lordship. They have separated in the year 2022 by intervention of the Blaze authorities because of their misunderstanding. They could not continue their
Actually,
life
Mr.
together.
Lolen,
Lordship.
if this is a common application, the respondent number, the petitioner number 1 should also file an affidavit.
Lordship.
Or she has filed.
Yes, affidavit
Or
filed.
both has filed. Oh,
Yes, Lordship.
Okay, all right.
Lordship, here, while they have separated from each other, some important documents like Lordship, Aadhaar card, PAN card, gas card, money first, everything was left at the rented house where both they sat together
They are
earlier.
husband and wife.
Yes, Lordship. And on 29/10/2022, the petitioner number 2 husband, they entered into the rented house at 9 a.m. Lordship. He entered at the rented house of the petitioner number 1, complainant. And just
who lost the FIR?
Petitioner number one, Lordship. Petitioner
The wife.
number two is the husband, one is the complainant, wife.
Wife lost the FIR.
Yes.
Oh, sir.
So petitioner number two, husband, he entered into the rented house of the wife, petitioner number one, for collecting his important documents only, Lordship. And out of,
Okay, what do you say?
Yeah, your lordship, since they have settled the matter, so there is a remote and bleak
Yes,
chance
they
of
have
conviction,
already
so it
settled,
may
lordship.
interfere, your lordship.
Okay, it is quashed.
Yes, sir.
yes, deeply
Obliged,
obliged.
lordship.
Lordship, we have received the LCR, Lordship, let the matter may be fixed for admission hearing, Lordship.
Hmm?
We have received the LCR, Lordship.
Yes. Heard the learned counsel, Mr.
Pardon?
Appearing for a petitioner. RMS H. Lakshmi, the learned judicial public prosecutor for the state of Arunachal Pradesh. List this matter after 3 weeks for admission hearing.
Your lordship, 2 weeks.
After 3 weeks.
Obliged.
May I please, Lordship?
Yes.
Lordship, this is a joint application for the quashing of criminal proceedings sub judice before learned Jam FC UPR arising out of motor vehicle accident. And this application is filed on the strength of the mutual settlement being entered into between the petitioners.
Where is the FIR?
Lordship, may kindly came at
Page 29.
Yes, my lord, phase 26 is the charge sheet and FIR, Lordship, at 28, my lord, phase number 28, and typed copy is at 29, my lord. The FIR being lodged by the petitioner number 1, who is the mother of accused person. Petitioner number 4, my lord. And
Who is
Lordship,
respondent number 3?
Lordship, respondent number 3 is driver of offended vehicles.
And who is respondent number 4? Son of respondent number 2.
Respondent number 2 is, my lord, the mother of the victim, and the respondent number 4 is the accused person.
No, who is the son? Son of the respondent number 2?
The son of the respondent number 2 is the felon rider who succumbed to the injury out of that accident, motor accident, my lord.
He is not a party.
His mother has been made as a party.
How old is her son?
Her son was, my lord, then he was a major 19 years old, my lord. Then
So he has to be made a party.
has been made a party, my lord, as a
What
petition
is his
number.
name?
Pardon, my lord.
What is his name?
My lord, his name is a Cargo Jelly. And the cause title of petitioner number 2, Cargo M, the mother of late Cargo Jelly.
No, I am asking you that the FIR was lost by the mother
Yes,
because
mother.
somebody hit his motorcycle.
Yes, my lord. FIR was lodged by the.
The son is to be made a party.
Yes, my lord. Son is made as a party at the petitioner number 4.
Petitioner number 4.
Yes, my lord. Initially, the
Second,
FIR was lodged by the petitioner number 1 against the petitioner number 3, who is the driver of offended vehicles. But during the investigation, it has been found that the bike rider, the petitioner number 4 and the son of petitioner number 2 were coming from the wrong direction. Accordingly, the petitioner number 4 has been charge sheeted, my lord. So
But
petitioner,
the husband's name of respondent number 2 is Kago Orming,
yes, my lord.
but the father's name of the respondent number 4 is something else, Sri Tao Main.
My lord, yes, my lord, the son of respondent number 2 is the felon rider of respondent number 4, who is the accused person. So out of that motor vehicle accident,
So who is the son of respondent number 2?
my lord, respondent number 2 is the mother of the felon rider who has succumbed to that accident, my lord.
Tatung Main.
Yes, my lord. And the respondent number 4 is the
Tatung Main. So why father's name is different?
they're a different person, my lord.
Huh?
They are different person, my lord. The Tatung Maing, petitioner number 4, is of resident of the Upper Seven Street, Darfur region. And his felon rider is the Kago Jelly, who is the resident of Jiro,
No, you are not understanding the fact.
my lord.
Mother has alleged that her son Tatung Main
Yes, my lord.
was injured after a gas car hit him.
Yes, my lord.
Okay.
Yes, my lord.
So according to you, Tatung Main is 19 years old
Then, my lord.
at that time.
Yes, my lord.
Now he must be more than 20 years old.
My lord, it is the case of 2013, my lord.
Yes. So here is respondent number 4 is Tatung Main,
Yes, my lord.
son of Tao Main,
Tao Maing, my lord.
permanent resident of Main,
Yes, my lord.
Upper Subansiri.
Yes, my lord.
But the informant's name is Srimati Kago Yam.
No, my lord. Informant's name is petitioner number 1, Yanya Maing, my lord.
It's Yanya Main.
Yes, my lord. Informant's name is
Oh,
Yanya
Yanya
Maing.
Main.
Yes.
Oh, she has filed it.
Yes, my
Okay,
lord.
now it is okay. Now I understand.
And then more in addition, my lord, petitioner number 2, who is the
Tatung Main has filed the affidavit or not?
yes, my lord. This is a joint applications in affidavit, my lord.
Oh, Tatung Main has filed the affidavit.
Yes. In addition, my lord, the petition number 2, who is the mother of deceased, has already received the debt compensation
Okay,
that I
alright.
have annexed, my lord.
Oh, it's a debt compensation receipt.
Yes, my lord.
Saying, what do you want to say?
It was not, appears to be not intentional, my lord. It's just an accident case. Moreover, the parties have settled.
Okay, I'll pause it. Please pause.
Much obliged, my lord. Obliged.
Lordship,
Yes.
I'm appearing on behalf of conducting counsel, Mr. Elbam. Just now, I have been informed that he is not appeared today, having some personal difficulties.
Okay,
And I have been instructed to seek an adjournment.
okay, all right. Heard Mr.
J. Karbak,
Appearing on behalf of Mr.
Elbam.
Elbam, the learned conducting counsel for appellant. Mr. So-and-so has submitted that Mr. Bam has some problem today, and on that ground an adjournment has been prayed for. I have also heard MST Genie, the learned additional public prosecutor for the state of Arunachal Pradesh. Who is appearing for respondent number 2?
Lord, respondent number 2, no one is appearing. The person shown in the calls list is in fact the counsel for the appellant.
Firstly shows the name.
Yes. But then I have just confirmed
Oh,
he is the counsel for the appellant.
who was?
Or CTEC.
Huh? Oh, Omin Sitek.
Yes,
He was earlier counsel for the appellant.
appellant. It has wrongly been reflected
He is
in
wrongly shown.
yes.
MS Jenny submits. Then in the cause list, Mr. Omin Sitek has been shown as the counsel for the respondents. According to MS Dini, Mr. Sitek was early representing, Sitek was representing the appellant. Therefore, his name has been erroneously shown as the counsel for the respondent. The registry shall remove that name from the cause list. Regarding respondent number 2, on behalf of the
Your Lordship, if I'm not wrong, Your Lordship, respondent number 2 is not a permanent resident of the state, Your Lordship, and therefore notices were sent to the state of Assam, Your Lordship. However, their addresses could not be found. If Your Lordship can appoint any amicus curiae in that regard for respondent number 2.
Can you tell a name?
Any name, if the registry have this.
The registry is directed to appoint one amicus curiae to represent the respondent number 2. Least after 3 weeks for hearing.
Okay.
Your Lordship, in item number 29, the legal aid counsel, Miss Jaya Doji, had just informed me this morning that due to some difficulties, she is not available today, Your Lordship.
Okay, all right. None appears for the appellant on call. RMS Gini, the learned additional public prosecutor for the state of Arunachal Pradesh. Least after 4 weeks for
Yes.
hearing.
Deep.
Over.